On March 3, 2023, George Allen Kelly was indicted by a Santa Cruz County, Arizona grand jury on charges of second-degree murder and aggravated assault in connection with the shooting death of Gabriel Quen Buitamea, who was found on Mr. Kelly's ranch property on January 30, 2023. Mr. Kelly and his wife lived on his cattle ranch near the U.S.-Mexico border. According to him, he fired warning shots into the air to protect his property and his wife from what he believed were armed smugglers, and that he did not intentionally target anyone. The case went to trial in March 2024 before Judge Thomas Fink in Santa Cruz County Superior Court in Nogales, Arizona. On April 11, 2024, Santa Cruz County Sheriff's Detective Barba, the lead investigator on the case, became a central figure in the proceedings. Mr. Kelly's defense team pursued a strategy similar to what is commonly referred to as a Bowden defense, which seeks to establish reasonable doubt not by disproving the prosecution's theory outright, but by demonstrating that the underlying investigation was fundamentally flawed, biased, or inadequate. By highlighting investigative failures and unexplored leads, the defense aimed to suggest that the prosecution's case rested on a compromised foundation. One event involved Detective Barba and Sheriff David Hathaway crossing into Mexico to interview a witness named Daniel Ramirez without adhering to standard international protocols or coordinating with Mexican authorities. Before defense attorney Brenna Larkin could confront Detective Barba with these issues on cross-examination, Judge Fink intervened and imposed time limits on the cross-examination.
We're on the record. Records show the presence of counsel and the defendant. The jury is absent. Mr. Jetty or Ms. Hunley, I need to know what remains of the state's case in chief.
We're currently in the cross-examination of Detective Barba. And after Detective Barba, we have Border Patrol Agent Tercy, which should be quick. I mean, this is from the state's perspective, quick from our perspective. And then we have the finishing up of dispatch witness on Friday and Detective Aienza. And that's it.
Thank you. What does the defense anticipate of its case in terms of how much time you're going to need?
Your Honor, we're hoping to get through it fairly quickly. We have Sheriff Hathaway, we have Border Patrol Agent Layugan, Border Patrol Agent Gorman, and Detective Raul Rodriguez that we anticipate calling, and then possibly the defendant, possibly not.
Give me an estimate of how much.
2 days?
2 days?
The way
I'm
things
just
are
asking.
going, I'd say yes.
Well, all right. I'm going to start imposing time limits in this case on direct and cross-examinations. When we've been discussing this case, leading up to the case, and during the trial, counsel advised me that this case would take 3 weeks. I have to rely on what you tell me. I don't know who the witnesses are going to be, what they're going to testify to, or what the duration of time is going to be. I was told it was going to be 3 weeks. Today is 3 weeks, right? Today is 3 weeks. We started on March 21st. Today's 3 weeks, and the state's still in this case. I've also been monitoring and asking counsel for how we're doing, how we're progressing on this case, so that I could decide whether and determine whether I needed to exercise any authority over the pace of the case. I was informed by the state that there was a possibility that they would rest last Friday. Here we are on Thursday. The state's not going to rest today, and if we continue, then the state will maybe rest at the close of business on Friday. I assume Detective Aienza is going to be a lengthy witness. So clearly, we are behind schedule. This case is going to go to the jury next week. It's going to go to the jury next Thursday, and I'm going to move this case so that that happens. And I'm going to start imposing time limits. This line of cross-examination of Detective Barba, tell me what it is, tell me why it's relevant and what you're trying to do.
Are you referring to Ramon, to Detective Barba about Ramon?
I am.
Ramon is somebody who came forward in this case. He made a false report to law enforcement. Law enforcement collected information from Ramon that was verifiably false. Law enforcement failed to exercise any kind of standard of care over this investigation. It shows law enforcement's bias, and it shows their ineffectiveness in actually being able to investigate the case. It's crucial to the defense to be able to put on this information.
So the line of questioning is basically, well, first of all, Ramon's not a witness, right?
Correct.
He's not going to testify. Ramon came forward, he gave information. Is the defense point of view an argument that he gave false information, correct? All right. they looked at Ramon. They decided for whatever reason not to use Ramon, maybe in part because he wasn't an honest witness or he's not available. But so basically what you're trying to prove is that, as I understand it, through this cross-examination, is you have a witness who gave false information, he's not being used, and you're just trying to determine that the state didn't adequately investigate his false information?
That's true. He's also a potential suspect. Judge, anybody who comes forward to put themselves at the scene of the crime should be looked at as a person of interest. We had a witness testify that because Mr. and Mrs. Kelly were at the scene of the crime, they were persons of interest. Anybody who puts himself there is a person of interest, if not a potential suspect, and we have a right to question the investigation and to challenge them and to get to the bottom of why they didn't pursue other people who are making false reports and maybe potential suspects.
Very well. You can do that, but this examination is way beyond the scope of the direct examination. This is evidence that is more properly presented in the defense case in chief. You can present that in the defense case in chief if you want. We're not going to go into it any further right now. It's beyond the scope of the direct examination, and it's more evidence that's to be presented in the defense case in chief. If you wanted to present that in the defense case in chief, you can do that. And if you do that, because of the way we've discussed this yesterday and the ruling of the court, is that then we're going to play the entire video of the interview. And I don't know, did you determine how long that's going to take?
It's only 20 minutes, Your Honor.
20 minutes, that's good. But that'll come out in your case in chief, and that'll come out of the defense time.
I just have to object, Judge. I think that's going to cause this to take longer. If we have to recall Detective Barba to go through that, it'll take longer. I'm allowed in cross-examination to exceed the scope of direct. I'm not in any way limited by what the state asks this witness on direct. And if I have to call this witness in our case in chief, then I'm not able to lead the witness, so that's going to take
You'll be able to lead the witness. He's an adverse witness. I'll allow you to lead the witness. The rules provide that if you call a witness and he's associated with an adverse party, the court can allow that. That's the ruling of the court. Let's call the witness to the stand. We're not going to question the witness anymore on this particular point. You have 5 more minutes with this witness on cross-examination.
Judge, I have to object. This witness is very crucial to the defense. I've never been limited to the lead detective. This is the witness who's supposed to be the lead detective. I've never been limited to just 5 minutes of cross-examination. And this witness testified to all sorts of involvement in this case. This is one of the defense's main witnesses that we have to get to. Judge, limiting me to 5 minutes of cross-examination with this witness violates Mr. Kelly's constitutional
You now have
rights.
4 minutes. Call the witness.
During Detective Barba's cross-examination, Judge Fink imposed a strict 4-minute time limit on the defense, prompting Ms. Larkin to formally object. Under Arizona Rule of Evidence 611, which grants courts reasonable control over the mode and order of examining witnesses, but makes clear that such discretion cannot come at the expense of a defendant's right to fully explore the scope of the direct examination. In her view, cross-examining the lead investigator was not a peripheral matter, but a cornerstone of the defense's theory of investigatory bias, and 4 minutes was wholly insufficient to accomplish that. Judge Fink, however, ruled that certain lines of questioning, specifically those concerning an individual referred to as Ramon, fell beyond the scope of what the prosecution had covered on direct examination. Even as Ms. Larkin argued that the defense was entitled to exceed that scope for the purpose of impeaching Detective Barba's credibility, the court held that such inquiries were better reserved for the defense case in chief, the phase of trial during which the defense presents its own witnesses and evidence. Ms. Larkin pushed back on procedural grounds as well, contending that recalling the detective at a later stage would be inefficient and that judicial economy favored addressing these issues immediately. Judge Fink denied that request, deferring to the court's existing schedule. The defense escalated its objection to constitutional dimensions, invoking the Sixth Amendment's right, which guarantees every accused person the right to be confronted with the witnesses against them. Ms. Larkin argued that confining cross-examination of the state's lead detective to a matter of minutes effectively rendered that right illusory, stripping the defense of any meaningful opportunity to test the prosecution's evidence. Judge Fink ultimately sustained the limitation, but preserved the defense's ability to call Detective Barba as their own witness during the defense's portion of the trial.
All right. Witness is still under oath, and you can continue with your cross-examination.
Thank you. So if you're giving this person the benefit of the doubt, then you should give Mr. Kelly the same benefit of the doubt, correct?
Well, I'm not giving anybody the benefit of the doubt. I'm just stating what my training and my experience has taught me.
You have training and experience regarding false reports also, correct?
That's correct.
And could that also be something that explains why the story is so different from the facts?
It's sure.
It's a possibility that this just could be a false report, right?
In the evidence that we gathered throughout the investigation, I don't believe so.
If somebody came forward and gave you this story, you would still say that that's a credible person who gives you this story.
That, including everything else that we gathered in the investigation.
When you interviewed Daniel Ramirez, is that correct?
Yes, ma'am.
You went into Mexico to interview him, correct?
Yes, ma'am.
Why did you go into Mexico to interview him?
Because Daniel couldn't cross into the United States legally.
You could have called him on the phone, right?
He doesn't have access to a phone.
You could have arranged some sort of Zoom call, correct?
He doesn't have access to internet.
You could have spoken with Mexican officials to arrange something, correct?
Correct?
And you didn't do that, did you?
No.
You and Sheriff Hathaway crossed into Mexico to conduct a criminal investigation in Mexico, correct?
Well, it was a witness statement, witness interview.
Is taking a witness interview part of a criminal investigation?
Sometimes.
Was taking this witness interview part of a criminal investigation?
Yes.
So you conducted part of a criminal investigation in Mexico, correct?
Correct.
All right, thank you very much. Redirect examination.
Thank you, Your Honor. Detective, defense counsel asked you a number of questions about the Celebrite download of the victim's phone. Do you recall that?
Yes, ma'am.
She asked you about text messages, correct?
Yes, ma'am.
And can you tell us, she asked you, were there other messages on the phone?
I just want to make sure that redirect is limited in the same way that my cross-examination was limited.
You can continue.
And I'd like to make a proffer when we're done with this witness.
You can continue.
During her cross-examination of Detective Barba, Ms. Larkin secured a notable concession early on. The detective acknowledged, based on his own professional training, that witness statements carry an inherent risk of containing false reports. Rather than conducting the interview through remote communication or formal international channels, Detective Barba and Sheriff Hathaway had physically crossed into Mexico to speak with the witness in person. Under international law and the Mutual Legal Assistance Treaty between the United States and Mexico, law enforcement activities carried out on foreign soil are generally required to proceed through treaty-mandated cooperation with local authorities. By establishing that investigators had bypassed those formal channels entirely, the defense advanced a multi-layered argument that the resulting statements lacked a verifiable chain of custody, that the interview was conducted without the procedural safeguards necessary to ensure its legitimacy, and that the decision to avoid official oversight mechanisms cast doubt on the reliability of the investigation as a whole. Ms. Larkin further sought to undermine Detective Barba's credibility by confronting him with prior sworn statements that conflicted with his current testimony. Under Arizona Rule of Evidence 801, a witness's prior statement is not treated as inadmissible hearsay when the witness is testifying at the current proceeding and subject to cross-examination, and when the earlier statement was inconsistent with the present testimony and was made under penalty of perjury, such as before a grand jury. By satisfying both conditions, Ms. Larkin was able to place Detective Barba's shifting narrative directly before the jury, simultaneously calling into question the accuracy of the investigation and eroding the detective's credibility as the state's lead witness.
The records show the absence of the jury. Ms. Larkin, you said you wanted to make an offer of proof concerning Detective Barba. You can do so. The court reporter and the clerk will remain in the courtroom to record your offer of proof.
Judge, can you hear me? Oh, okay. Cool. So in addition to obtaining testimony about the false report provided by Ramon, the cross-examination was going to continue to explore inconsistencies between Ramon and Daniel in terms of the inconsistencies that they've made with each other, as well as inconsistencies that their statements were with the physical evidence. The cross-examination was going to further explore the interview that took place with Daniel in Mexico, including exploring inconsistent statements between what he told investigators in that interview and what he testified to in trial in this case. That interview is going to continue to explore the fact that Daniel provided a false name to law enforcement in this case. And the cross-examination would also go into generally the shell casing testing that was ordered, the forensic testing that could have been ordered, the forensic testing that was not ordered, and further exploring the double standard between the way these so-called witnesses were evaluated versus the way that Mr. Kelly was evaluated, and the cross-examination would continue to explore the inadequacy in this investigation in terms of interviewing people who came forward, who placed themselves at the crime scene as possible suspects.
Wait a minute.
And we just want to make a further record, sorry Denise, you okay? Make a further record that the fact that our cross-examination was significantly limited violates Mr. Kelly's right to confrontation of these witnesses and due process.
While Judge Fink stepped away from the bench, the defense used the opportunity to formally place an offer of proof on the record pursuant to Arizona Rule of Evidence 103. Under that rule, a party seeking to preserve a claim of error based on excluded evidence must inform the court of the substance of what was excluded, ensuring that an appellate court can later evaluate precisely what the jury never heard and whether that exclusion prejudiced the defendant's rights. In practice, the offer of proof transforms a trial court's evidentiary ruling into a reviewable record, laying the groundwork for any future appeal. Ms. Larkin used that record to paint a picture of what she characterized as a shoddy and inadequate investigation. Central to her argument was the state's reliance on Daniel Ramirez, a witness who allegedly provided a false identity to authorities during the cross-border interview. By building its case around an unvetted witness whose very identity was in question, the defense argued that the prosecution had denied Mr. Kelly a complete defense, constructing its theory on an unreliable foundation that had never been subjected to proper scrutiny. The defense also raised what it described as a double standard in the state's forensic approach. Ms. Larkin argued that investigators had failed to conduct DNA or fingerprint analysis on other individuals who may have been present at the scene, and that this selective application of forensic protocols amounted to a violation of the Due Process Clause. Taken together, the offer of proof framed the court's time restrictions not as a routine scheduling decision, but as a constitutional infringement. The defense argued that by preventing counsel from fully cross-examining the state's lead investigator, Judge Fink had violated Mr. Kelly's Sixth Amendment right to confrontation and his 14th Amendment right to due process, denying him the opportunity to meaningfully test the conscience of the very officers who had built the case against him. On April 22, 2024, after more than 2 days of deliberation, the verdict ended up in a mistrial. George Allen Kelly votes were split by 7-1 in favor of not guilty on the charges of the second-degree murder charge or the lesser charges of manslaughter and negligent homicide. In July 2024, Judge Fink ordered the case dismissed with prejudice, meaning it cannot be retried on these charges. After the case, Judge Thomas Fink received heavy criticism about his judicial conduct. Under the Arizona Code of Judicial Conduct, Rule 2.8, a judge shall be patient, dignified, and courteous to litigants, jurors, witnesses, lawyers, court staff, and others with whom the judge deals in an official capacity. Judge Fink even received a formal complaint about his judicial conduct by Peter Petotsky, citing all the other rules that he believed the judge didn't follow through. Several months later, on November 22nd, the commission issued its response to the complaint, determining that Judge Fink appropriately limited cross-examination. At the same time, it found that he acted improperly by leaving the bench while the defense attorney was making a record. Despite this, the commission declined to impose formal discipline and instead dismissed the matter with a warning letter to Judge Fink. This episode illustrates just how heavily a case can turn the lengths to which a judge's temperament can shape the record of a trial. Over the course of the trial, defense attorney Brenna Larkin sought to dismantle the state's narrative by exposing deep fissures in the law enforcement investigation. However, the judicial conduct of Judge Thomas Fink became a flashpoint when he imposed severe time constraints on Larkin's cross-examination, eventually leading to the moment where he stood up and walked out while the defense was making a vital offer of proof. This behavior ultimately drew a formal warning from the Arizona Commission on Judicial Conduct, which noted a failure to remain patient, dignified, and courteous under the judicial conduct. Ultimately, the jury deadlocked with a lopsided 7-1 vote in favor of acquittal, leading to a mistrial. Recognizing the lack of substantive evidence, including the missing fatal bullet, Judge Fink eventually dismissed the charges with prejudice, ensuring that Mr. Kelly would not face a retrial. This outcome reflects both the jury's skepticism of the state's witnesses and the legal reality that a trial cannot be fairly conducted when the procedural rights of the accused are weighed against a ticking clock. Now, let us know if there is a case or courtroom interaction that you'd like us to explore in the comments down below. Thank you for watching, and don't forget to like and subscribe so that we can help foster a more informed society.